Hi, good afternoon, everyone. Yeah, so our first uh, thing to cover, I mean, some of this, I suppose, technically are not predictions as such, but changes. This particular slide sets out the usual annual increases, changes that happen on a yearly basis in most cases. In April, we'll have an increase in national minimum wage levels. The rate for people aged 23 and over, the national living wage, is going up to £10.42 per hour. I won't go through each of the rates, but just to give you an idea, they're all essentially 9.7% uplift from the previous year or more. And so those can be found on gov.uk website, or just Google it to get those kinds of rates. And this is something that goes up, generally speaking, on a yearly basis. The current government have indicated targets that they're looking to meet in the next few years to continue increasing national minimum wage. So I think we can continue to expect it to increase year on year. Then you've got the statutory rates. Statutory maternity pay, you've got the family, essentially the family statutory pay, statutory paternity pay, adoption pay, shared parental pay, parental bereavement leave pay, and so on. And they're all going up to £172.48 per week from £156.66. So it goes up a little bit. Obviously, a lot of this is sort of recognising inflation. Finally, the statutory sick pay within the statutory rates, and that's going up from £99.35. It's going over the £100 now to £109.40 per week. Obviously, most people's payroll systems will automatically adjust for those changes, but keep an eye on it and make sure that you're meeting that when they change in April. There's also employment tribunal caps, things like weekly pay, what falls to be described as weekly pay capped under the Employment Rights Act, or caps on claim values like unfair dismissal. Now, we don't yet have the new figures for those, but again, they tend to go up in April as well. So I would again expect an increase there. So then on to the perhaps less predictable elements here. And there are a number of potential changes afoot through Parliament in the next year. The first one is potentially a big one, the retained EU law revocation and reform bill. Now, I say potentially a big one. It's not really relevant to this year, but the following year, on the 31st of December 2023. We are anticipating, or the government have set this bill to trigger, and the principle is that it will sunset all EU-derived law from our legislative books. It will remove everything that came from EU directives, absent any further action. In practice, then, if the government in the intervening period decides to put in legislation that moves those rules over to our domestic legislation, then they could continue to apply, or the government might put in new legislation that changes things. The potential effect for employment is the removal of working time regulations, agency worker regulations, TUPE, and legislation around discrimination against part-time and fixed-term workers. So quite wide-ranging and potentially chaotic. Many commentators are saying, if it just goes without any intervening legislation. The bill, interestingly, is due to have its report stage and third reading tomorrow. So I can't really report on any new developments as such. But I suppose there's sort of three potential outcomes by the end of the year. The first is that the retained law bill passes and is triggered on the 31st of December as planned, and no intervening legislation is put in place, in which case a lot of our employment rights, the employment rights for employees, will fall by the wayside. Now, that's obviously potentially very chaotic and confusing for employers as well, and we'd have to look at how robust employment contract terms are, because there'd no longer be statutory provisions in place, and potentially things could change quite dramatically. That's the first potential thing. Possibly the most likely thing is that, in fact, they could just push it back. The bill itself has a mechanism to push it back to 2026. Or they could essentially put some new legislation in place. There has been for many years talk of a new employment act, which just hasn't come to fruition yet. I don't know if you have any thoughts on whether that's coming in, Claire, but it hasn't come into kind of any kind of fruition. And similarly, there's been talks of Bill of Rights, which again, I think they'd really have to be rushing to get those kinds of bills through Parliament in this year alone. So they could simply put some legislation in place to keep the working time regulations, the agency worker regulations, and keep it going. I don't know. What do you think, Claire? What's your prediction on which of those might be the most likely outcome?
I think with the current trade union disruption that's happening this year, the fact that there's no current end in sight for that, and the time that is inevitably going to take up within government in terms of negotiation, I would predict that unless there's an early resolution and time is freed up, that they'll make use of that extension, which could go as far as June 2026.
Yeah, I think that's entirely possible. Obviously, it's going to depend on the government's priorities at the time. They have stated they obviously want to get this bill through quickly. So it may be that they simply put in place a piece of legislation which just incorporates the EU-derived law into domestic law, and then they can get rid of it whenever they want anyway. Okay. Anyway, moving on.
Some pressure from there's certainly pressure from employer organisations to sort it early, and certainly before the next general election, isn't there, to avoid debate and uncertainty around that time, which
I think for both employers and employees, but both for employers and employees, if something isn't resolved, it's going to be very, very chaotic. And a word I've used now, I think 3 times. Moving on then, there are a number of private members' bills which are in various stages. The first I think you were going to talk about, Claire, is affects redundancy.
Yes, in terms of the proposals around redundancy, are we talking now about the protection for pregnancy, aren't we? So obviously we've got currently an arrangement whereby women who are in the protected period are protected from unfair redundancy selection and are given priority for suitable alternative employment during that protected period. And so that at the moment there is a proposal to prohibit that redundancy and dismissal by reason of redundancy during the protected period, which will extend to 6 months post the end of that statutory leave period. So that will also include people on shared parental leave and adoption leave, as well as women who are absent due to maternity leave. Again, we're waiting for details on exactly what protections will be afforded to each different group, and whether women on maternity leave in the protected period will have extra protections still, but we'll wait and see for more detail on that.
Absolutely. Then the next one is, I think I'll stop sharing the slides so you can get a clearer view of us. But the next potential change then private members bill is as Claire sort of alluded to already, the strikes minimum service levels bill. There is a high degree of proposed industrial action at the moment and current industrial action. And the government have proposed this bill essentially in an effort to ensure minimum service levels for what they're calling blue light sectors, emergency sectors. Now, it has to be said, the bill itself is wider than that at the moment. It includes things like education and transport, which arguably isn't necessarily emergency, but which the government have included as necessary to our way of life and democracy, I suppose. And the drafting itself is quite wide. Interestingly, it was debated at second reading yesterday. My understanding is it's been proposed, it's been voted quite unanimously to go through to the next stage, for reporting stage. But at the moment, the bill itself, where it refers to the sectors that are involved as health, fire and rescue, education, transport, the decommissioning of nuclear installations, and border security. But they're that's all it says on the subject. So they're not defined terms as such. So health appears to include any health industry, including private and public. Education, the same, would include academies and private education and so on. So potentially there could be regulations put in place that would require a work which would potentially require this minimum service level. And what it means is essentially an employer facing strike action in these sectors would be able to serve a work notice on the union that identifies that employees need to meet a minimum service level. And once they've sort of issued that works notice, the union has a duty then to take all reasonable steps to ensure that all members of the union who are identified in the work notice, it has to specifically identify individual workers who are needed to meet this minimum service level, and that they continue to work. If the union doesn't comply, it loses its immunity from being sued, and any employees who refuse to turn up who are identified could then be dismissed for unfair dismissal. It could be fairly dismissed, sorry, without the unfair dismissal protections. So it's quite wide-ranging as it's drafted. I suppose we sort of expect that there may be some changes through the debate process and amending process, or at least some clarification. And not to get into the politics of it, I think it's clearly a priority the government have pushed through quite quickly, and I think that's the reason that the drafting is a bit wide at this stage, because it's a bit of a rush job, if I could put it that way, or they're trying to get it done quickly, given the current stage of, I think the headlines yesterday were saying that it's a record number of days have been lost already this year in the last 12 months of strike action. So it's a big priority for the government. Moving on to the next one then, Claire, was the flexible working bill.
That's right. So again, this has received quite a lot of publicity already, and so the government has been consulting around this subject for some time. And I think again, with the ever growing popularity of employees valuing the importance of the choice in terms of a work-life balance option around their working life, this is no doubt going to be something that will be picked upon quite quickly as soon as it becomes an option for individuals. And so the proposals are that the right to request flexible working will be opened out to being a day one right for any employee to make a request. And there'll be some changes to the process that's currently involved in dealing with that request, including the removal of the burden on employees who currently have to fill out quite a prescribed application form, whether that's in a form or a letter format, depending on your policy. But within that, they need to explain the potential impacts that their flexible working pattern might have on the organisation that they're employed by, and how the employer may overcome that. And obviously that takes some thought for the employee to have to put together as part of their application process. So that aspect is going to be removed. Employees will also be able to make 2 requests in a 12-month period rather than the 1. And the response deadline time frame for employers to complete the process and give their decision and response to the request will be reduced from a 3-month to a 2-month time frame, which actually is quite short, depending on when within your busy period such a request might come in. In addition, if you're proposing to reject a request, you're going to be required as an employer to consult with an employee around that you're considering rejecting that request, which again would fall within the best practice guidance from ACAS anyway. At the moment, again, this is going through legislative review. There hasn't been a final piece of legislation approved and a date for the legislation coming into force, but those are the current proposals within the bill.
The next ones, I've sort of put a couple together. They both relate to care in a sense. Again, these are bills that have been produced after consultation and the Taylor Good Work Review. Essentially, you've got the neonatal care leave and pay bill, which is intended to as a day one right for employees to be entitled to up to 12 weeks of paid leave to enable them to spend more time with babies requiring intensive care, essentially. And then the carers leave bill, slightly different. Again, a day one right, but it's a week's unpaid leave to help employees with long-term caring responsibilities, balancing those with their paid work. So it sort of essentially gives the employee the right to request a week off unpaid to do caring duties. So I think they're probably both fairly non-controversial and will pass, albeit how they're drafted obviously may go through a bit of a process. Yeah, those are those ones, and then worker protection, isn't it? Yeah.
So quickly moving on now to a proposed update to the Equality Act. And again, this is something that for those of us who watched the Equality Act come into force in 2010 will be very familiar with the provisions that were in there. So the first is to introduce a new proactive duty on employers to take all reasonable steps to prevent sexual harassment in the workplace. And again, that forms part of your statutory defence if you're able to show that you do that in defending a claim. But of course, there is now going to be this proactive requirement to do so. Secondly, is the proposal to reintroduce something that was drafted into the legislation in the first place, which is the duty to protect employees from third-party harassment, such as harassment by clients, customers, and other third parties. And again, so that those of us who've been in the job for some time will not be surprised that this is proposed to be reintroduced, and particularly in light of some of the most recent high-profile cases that have come into play in the public domain. So again, that's just something to watch out for this year.
Another sort of the final one we've got in terms of private members bills that are in discussion at the moment is one in relation to allocation of tips, obviously for the hospitality sector, really, and really it's a bill intended to ensure that employers are distributing tips fairly amongst employees without taking any cut for themselves, and making sure that everyone's getting an equal cut, essentially.
That's right. And obviously deductions will still apply for tax and national insurance purposes.
Absolutely,
but what you're talking about is that it will be unlawful to make some form of administration charge and that type of retained, or to deduct from tips anything to do with some other form of penalty.
Yes, absolutely. So anyone in those sectors, obviously, consider or keep an eye on that one, because it will potentially change how you handle tips. Okay, and I'll go back to sharing so that we can talk about our next slide. So we have some other potential changes and predictions, which are sort of obviously a bit less set in stone where there isn't already a bill in place. Hybrid working, Claire, what do you think about how is it here to stay? It's a big question, really.
Yeah, I think for now certainly it is, and more requests are coming in from our clients to update hybrid working policies, to make more permanent the arrangements that have been kind of put in place, whether that's through some form of informal arrangement that's now really developed into a settled practice. And I think obviously the key for all of you is, as you're coming to review your contracts, review your handbooks, it's something to keep under review, to update appropriately, to make sure that you're happy that the arrangements are working for not just your employees but also you as an organisation as well.
Yeah, I think when you factor that into the flexible working bill as well, I think there's almost an expectation now that employees should be able to work more fluidly in certain sectors,
Depending
obviously,
on the role.
Depending on the role, this is it. But that there is at least the opportunity for them to ask to work more fluidly, more hybrid, or more flexibly. annual leave, I've mentioned this Harper Trust and Brazel case. For those who aren't familiar, it was a Supreme Court case decision at the end of last year, albeit there had been previous court decisions leading up to it, which essentially changed or didn't necessarily change, but cemented the way in which annual leave needs to be calculated for part-year workers. The government have launched a consultation in the last, I think about 7 days ago, following this decision. The decision requires that all part-year workers still entitled to 5.6 weeks statutory minimum annual leave, and that it should be calculated with reference to a 52-week average pay, but skipping any weeks that they're not remunerated. So if someone's on a 0 hours contract or a term time contract where they're not paid every month or every week, you would take an average of their pay, but you would skip any weeks that they didn't work, essentially, that they weren't paid, up to a maximum of 104 weeks going back. Now, the government consultation, which is due to be concluded in March, is proposing essentially to change that so that the average weekly pay would be averaged over 52 weeks, but it wouldn't skip non-remunerated weeks. For my money, I think that makes sense, because otherwise what you've got is potential part-year workers who don't work the full year, who may only work a few weeks in a year, receiving pay that averages over a much longer period and doesn't take into account that there are weeks they haven't worked. If the government consultation is, if they get a positive result, response from it, and they decide to make that change, it will mean that, sure, someone on a part-year worker contract that only has done a couple of weeks work, they're still entitled to 5.6 weeks holiday, but their average pay to be paid during those holiday days would be comparable with what they should be earning, because they've only done a couple of weeks work. So it would be pretty low because they've only done a couple of weeks in that year. So I think that's my view on probably where it's heading, albeit when that actually would be put into legislation is another matter, and it's something still to consider if you've got term time, part-time workers, or 0 hours contract, workers on an umbrella contract that a permanent contract, but only working part year. Definitely still something to consider.
Thanks,
Fire
Michael.
and rehire,
yeah, fire and rehire. So really, again, it's already been confirmed that new legislation is not going to be proposed in relation to fire and rehire. Obviously, we'll all recall how this became something of debate, particularly after the P&O situation and the media around that. However, the government are proposing to introduce a statutory code of practice on dismissal and re-engagement. And they've obviously said when parliamentary time allows. And again, this is an indication of quite, I suppose, how far behind they are in terms of introducing their nice to haves. If and when they do get around to introducing that code, it's intended that there'll be some form of potential uplift for compensation available to judges in relation to successful claimants where an employer has failed to follow the code of practice in dealing with these processes. But there is an acknowledgement from government that within certain circumstances, it will be necessary for employers to consider fire and rehire as a last resort, where it's going to be necessary to save a business and potentially to protect remaining jobs. So that's where we are with fire and rehire.
Lovely. Then, quite simply, there's an extra bank holiday this year, the coronation of the King on the 8th of May 2023. There'll be an extra bank holiday. We had that last year, so probably most employers are familiar with this. The only thing to check is that whether your contract actually in the annual leave clauses includes bank holiday rolled up with, not rolled up, but along with the full holiday entitlement, or whether it's stated to be separate, in which case, or whether your office has a closure on bank holidays anyway, as to whether you need to give your employee that day as a holiday. That's really it for bank holidays.
Yep. And then finally, from me, really, the ICO are constantly updating their website. It's recommended, and certainly one of my top tips for today, that you familiarise yourself with the ICO website. There's some really useful updates and guidances available in respect of compliance with the Data Protection Act provisions and your obligations, and of course your employee obligations as well. It's something that we regularly provide in-house training on for our clients, if that's something that you might benefit from. There is a proposal that there'll be a move away from some of the more prescriptive reporting and procedural aspects of compliance, and take a more kind of risk-based approach to compliance, with a view to removing the extra burdens on employers. And so again, we'll wait and see a little bit more about how that's going to look closer to the time.
And finally, then I threw in worker status. To a certain extent, it's a no change prediction. It's like a couple of hours. Last year, the government actually held a consultation again on worker status, or employment status, recognizing that we've got these three different levels of employment as an employee, a limb B worker, as it's often known, or self-employed. And also then we've got the IR35 and tax regulations, which apply a similar but actually slightly different test as to whether someone is employed for the purposes of paying income tax. And the consultation went on for a while. It was very detailed. To summarize the response, which was published in July 2022, they really the government accepted that it can lead to confusion. It is not desirable that we have these two regimes of employment status and tax status that broadly is similar, but they don't align, and they're not required to. And essentially said it would like to address and align those frameworks together, but they said they had more important matters to attend to. They did publish some guidance on status and interpreting status, but they really kind of came to the conclusion they weren't going to change any legislation anytime soon. Obviously, there are some calls to remove the whole concept of a worker, so you've just got employee or self-employed, which I appreciate makes things simpler, but also the reason we have that worker status is because there are differing levels of employment rights, and we still are to a certain extent in a kind of gig economy, which I think the government is and appears from what it says in the consultation, because they do seem to say they'd like to keep the worker status, because it allows for a greater flexibility of workforce without all the employment rights that entails of having full-blown employees. And really, I think that covers our sort of thoughts on changes and predictions for the coming year. At least there will be plenty more. No doubt there'll be cases that crop up that we may not expect.
No doubt.
There may be changes to these bills and to the legislation they're intending to pass, but I think
there'll be a lot more coming through in February, March in terms of updates, perhaps, as well. And so one thing I would be really interested in knowing is if any of you who are here today are actually taking part in the 4-day working week trial, and how it's going for you, because I know that there are some initial quite positive reports for those who are trialing it, and I suppose that is a whole topic in itself, and whether or not that might be something of interest as an HR Lunch Club topic in the future. And please do let us know if that would be something you'd be interested in us having a longer talk around, and the things to think about if you're going to adopt that type of arrangement.
Yeah, absolutely. I don't know if anyone has any questions. We've not had any in the chat that I can see. If anyone feels bold and wants to come off mute and speak out, we'll be happy to hear questions. otherwise, as Claire said at the beginning as well, we're planning future HR lunch clubs. If you have any thoughts on topics you'd like us to cover, or you need some kind of more detailed and expansive webinars, seminars, training, we can accommodate. So do get in touch and book onto the roadshow. A recording will be available of this meeting, and our marketing team will send out links to attendees. So I'll get in touch with marketing, or they'll get in touch with you to give you a link to the recording. People interested in the roadshow just coming up on the chat.
That's great. Well,
Claire,
I hope you can all make it.
Yeah.
Well, I think those of you who are already on our database and receive our newsletters will have a link sent to you as part of our next newsletter. And for those of you who aren't, I'd love to invite you to join our newsletter. And in terms of how to book on, there will be a booking link sent out as one of the follow-ups to this session, I believe. We do have some of the members of our marketing team on this session. I don't know, Pete, if you're available, if you can answer in the chat, or if you can even put the booking link in the chat, that would be fantastic. But certainly for those of you who've already messaged, we'll make sure that that booking link comes out to you.
Okay. Maybe just give Pete or Jake a second if they've got the link. But other than that, I think unless anyone else has any more questions, thank you very much for attending. I hope it's been a useful overview of things to think about. Link will be going out this week. There we go. So thank you very much. Thank you, everyone.
Bye.